If your company is owed money by a business in Vietnam and communication suddenly stops, it may not be random. In some disputes, silence is a tactic. Debtors may delay, restructure, or create confusion to buy time and reduce your leverage. The good news is, these tactics are not unbeatable, if you respond with lawful steps, strong documentation, and a clear escalation plan. In this video, we break down common debt evasion patterns seen in practice, and how LTS law systematically counters them. One common pattern is restructuring, designed to separate the debt from the operating business. The debtor may transfer contracts, staff, equipment, or customer relationships to a new entity, often with a similar name, a new legal representative, and new bank accounts. On paper, it looks like the original debtor has changed. In practice, the operation often continues. Our response starts with lawful corporate tracing, checking enterprise registration information, mapping management links, and comparing transaction behavior before and after the change. The objective is to document continuity and prevent the debtor from hiding behind a new label. Some debtors change their legal representative mid-dispute to slow communications or to claim the prior representative had no authority. Others shift shares to third parties on paper to create the impression of new ownership and a clean slate. We counter this by building a clean authority and timeline record: who signed, who managed performance, who communicated, and who benefited from the transaction. When necessary, we structure the correspondence and filing so the debtor cannot easily escape accountability through internal changes. When contracts are bilingual, or when key documents are in English, some debtors exploit inconsistency. They may argue that the Vietnamese text differs, that certain terms were misunderstood, or that documents are not usable in formal proceedings due to translation issues. We counter this with disciplined document preparation, accurate Vietnamese translations where required, consistent terminology across invoices, delivery records, and correspondence, and a clear document index that ties the claim to specific contractual obligations. When a dispute escalates, clarity wins, especially when your dossier leaves little room for interpretation games. Another tactic is to create procedural noise. Debtors may raise counterclaims, jurisdiction arguments, or arbitration objections, sometimes with substance, sometimes mainly to delay. Even when these moves do not defeat the case, they can drain time and increase cost if the creditor is unprepared. Our approach is prevention and readiness. We test the dispute clause, verify notice requirements, and build a filing strategy that anticipates common objections. The goal is not to fight everything. The goal is to keep the dispute moving and protect leverage. In more serious cases, debtors attempt to reduce recoverable assets, moving property, receivables, or valuable business components to related parties. The right response must be lawful and evidence-based. We focus on mapping assets through legitimate sources, identifying inconsistencies in the debtor's story, and preparing court-ready arguments to challenge sham transfers where the law allows. Where legally justified, we consider procedural steps to preserve recovery options, so the creditor is not forced to win a case after the assets are already out of reach. Some debtors claim they are inactive, temporarily suspended, or no longer operating at the registered address. Others simply stop engaging to discourage the creditor. We respond by documenting real-world operations and continuity, contract performance history, supply chain signals, ongoing commercial activity indicators available through lawful channels, and the movement of key personnel or operations. If a company functions in reality, we build the file to show it, so inactivity claims do not become an escape route. A foreign supplier faced a large unpaid balance. Shortly before the due date, the debtor claimed it had transferred the business line to another company and therefore could not pay. We documented continuity, overlapping management links, transaction patterns, and operational signals that indicated the business had effectively continued under a new name. With a structured dossier and a clear escalation roadmap, the debtor re-engaged and settlement negotiations moved quickly. Details adjusted to protect confidentiality. The key was not aggressive language, it was credible evidence, procedural readiness, and timing. We do not rely on hope or repeated reminders. Our method is structured. 1. Early evidence organization and claim narrative building. 2. Asset and counterparty mapping using lawful sources. 3. Strong demand letters with clear deadlines and documented delivery. 4. Procedurally compliant filings that anticipate objections. 5. Enforcement planning with precise asset identification from day one. This is how we stay ahead of delay tactics and keep the timeline under the creditor's control. If your Vietnam counterparty has stopped paying, don't wait for more excuses. Every silent week can reduce leverage and increase risk. Contact LTS Law at lts.com.vn. We will assess the tactics, secure the evidence, and execute a Vietnam-ready strategy, so evasion does not become your loss. Because behind many excuses is a tactic, and behind every tactic, there is a lawful counter-strategy.